putting in danger not just your health break, but also your lunch hour. I'm indeed greatly honored and pleased to join you this morning for the official opening of this symposium. As you're all aware, this event has been organized by the judiciary under the distinguished leadership of my sister, the Honorable Martha Koome, the Chief Justice and President of the Supreme Court of Kenya, to mark the first decade of existence of the Employment and Labor Relations Court. This is a milestone that we are duty-bound to observe with adulation and great appreciation, given the highly commendable work the Employment and Labor Relations Court has done, and which underlines its position as a critical cog in the wheels of justice in this country. Similarly, this is an ideal moment to collectively review, make an assessment, and pick out operational challenges and hurdles that this court has faced in the last decade and continue to grapple with. We can then seek to address them to enhance the court's efficiency and effectiveness and enable Kenyans reap the intended benefits from its operations as an institution. The noble intention is well captured in the theme of this meeting, namely Employment and Labor Relations Court at 10, the place of Employment and Labor Relations Court in promoting social justice and economic prosperity, and the accompanying sub-theme, that is a decade of encounter with the right to fair labor practices, stakeholder experience. Based on the foregoing theme, I'm fully persuaded that we're in for very robust and enriching engagements that will culminate in practical and actionable resolutions with impactful outcomes. I note with keen interest that a session in the symposium is specifically dedicated to interrogating of employment and labor dynamics in the context of county governments. Topics to be canvassed include principles and practice governing county public service boards and interaction with county executives, evolution of resource practice in devolved governments, and the role of Salaries and Remuneration Commission towards realization of sustainable county public service workforce. As a Speaker of the Senate, which by dint of Article 96 of the Constitution is mandated to offer stewardship to devolution, I greatly commend the symposium organizers for the wisdom that informed this decision. Ideally, it goes a long way in confirming that a significant number of key actors are in sync with the reality that devolution is indeed an integral part of our lives as Kenyans, and whatever governance processes we embrace at the national level must be replicated in the devolved units in fulfillment of the aspirations embodied in Article 6 and the entire Chapter 11 of our Constitution. The Employment and Labor Relations Court is established under Article 162(2)(a) of the Constitution of Kenya 2010 and effectively operationalized under the Employment and Labor Relations Court Act number 20 of 2011. As the apex arbiter in resolving disputes arising in the employment and labor arena, this court has been instrumental in entrenching stability in a fluid labor sector, guaranteeing sustained economic activity and productivity. This has been achieved through a firm commitment to the rule of law and delivery of judicious and timely decisions that have not only placated aggrieved parties, but also expanded our jurisprudence. Permit me to invite you, dear delegates, to join me in commending the honorable judges and judicial officers of the Employment and Labor Relations Court for a job well done, and pray for them to maintain this very progressive and trajectory and commitment in serving the people of Kenya. Tunasema asanteni sana. Kenya boasts of nearly 20 million people in employment in both formal and informal sectors. As we all know, the employment space and work environment remain the theater of an interplay of the interests of key players, namely the employers, employers' caucuses, employees, trade unions, regulatory agencies, and countless other interested parties. The roles of these players are clearly spelled out in the labor laws of our land, namely the Employment Act, the Labor Institutions Act, Labor Relations Act, Occupational Safety and Health Act, and Work Injury Benefits Act. Collectively and individually, these legal instruments give life to Article 41 of the Constitution, which specifies the rights of employers, employees, employers' organizations, and trade unions in diverse work environments. In these tools, it is these tools that this court banks on as it arbitrates labor and employment disputes that find their way to its doorstep. This notwithstanding, the employment and labor market, as we know it, is persistently evolving with time and in tandem with socioeconomic trends at national, regional, continental, and global levels. It also faces challenges posed by rapid and anticipated technological advancements, global economic recession, geopolitics, emergence such as COVID-19, and lately the adverse impacts of climate change. All these undermine trade and industrial activity, minimize agricultural production, and generally leave us hanging on the precipice of an economic downspin. The net effect has been that in recent years, thousands have been rendered jobless, incomes reduced, even as we struggle for few limited opportunities in the workplace conflicts, and inevitably land in the chamber of judges of the Employment and Labor Relations Court. These circumstances constitute the realities of our time that we must contend and grapple with as we deliberate matters of employment and labor relations and assess the impact of the crucial court in our society. As the arbiter of the last resort in this sector, this court must all times embrace open-mindedness and deploy global best practices. It must continue to uphold the rule of law, which is the sole guarantee that as litigants leave the arbitration table, none feel shortchanged. This is because at the heart of the work of this court lies the element of relations, which it must strive to nurture and sustain at all times for the well-being of the parties involved. The point I'm emphasizing here is that arbitration must always be fair, impartial, and objective to ensure tranquility prevails even after the verdict has been rendered. And to underscore this particular statement, allow me to share with you words taught to us. When I say us, is the class of '98, and I can see some of us here. I can see Manduku. I can see even Justice Brian seated next to me here. When PLO was teaching us the importance of not just this court, but the judiciary, these are the words he used. That as government, mediocrity has no place anywhere in government, be it in the judiciary, in the legislature, or in the executive. But in the unfortunate event that mediocrity finds itself in government, then let it find itself in the executive or the legislature. It must not find itself within the judiciary. And PLO goes ahead to say, as a society, we can do with a mediocre legislature, because then the judiciary will be there to correct those mistakes. And as a society, we can do with a mediocre executive, because then the mistakes by the executive will be rectified by the judiciary. But we cannot do with a mediocre judiciary, because then who corrects the mistakes of a mediocre judiciary? And that's why, as the labor and the judiciary takes its place, there must be no mediocrity within its ranks. Ladies and gentlemen, as I conclude, allow me to affirm that as Parliament of Kenya, we remain fully committed and ready to undertake legislative interventions that will provide encourage to measures needed to enhance harmony at the workplace for sustained economic activity and productivity. With regard to county governments, the Senate remains diligent in ensuring the right legal frameworks are formulated to address issues of employment, labor, and human resource to diffuse potential conflicts. I look forward to a very insightful discussion and proposals from this forum on how we can undertake this duty together and escalate the benefits thereof. I thank you for your time and wish you a fruitful deliberation during the entire period of this symposium. May God bless us all.
Thank you very much, Speaker. We may revise PLO though. A developing country cannot afford a mediocre elite. Otherwise, it will forever remain undeveloped. Now, after listening to the Speaker of the Senate, and when he said he had 2.5 hours speech, I was about to say, order, Mr. Speaker, order. But you shortened it, thank you very much. Let us put our hands together and invite the Deputy Chief Justice of the Republic of Kenya and Vice President of the Supreme Court of Kenya, Honorable Lady Justice Philomena Mbetemwilu, who will give her speech, and subsequently invite the Honorable Chief Justice to give her keynote address. Welcome.
Good morning. That thing about protocol will be broken in the following manner. The Honorable the Chief Justice of the Republic, the Honorable, no, it's not just called Honorable, it's called Right Honorable, I think, the Speaker of the Senate, the Honorable Mr. Justice Maraga, under whom I served for 4 years. Thank you for being here for us. The honorable judges here present and all our partners. I just feel nice being here. Very nice indeed, because this court with which I am associated deals with that sensitive matter of employment. That matter where if you touch, you're touching not just the person affected, but a whole chain of persons. It feels nice to be here because today you're not 10 years old. In fact, on the 12th of July 2012, 12th of July 2012, the court as is currently known was born. And therefore, on the 12th of July last year, you turned 10 years old. And so, happy belated 10th birthday, my fellow judges on the court. And congratulations for starting the first year of your next 10 years in the great journey of serving the employment and labor relations issues in our republic. Today is a momentous day and occasion as we hold the first Employment and Labor Relations Annual Symposium and exhibition. This year the symposium forms a part of the ELRC at 10 commemorations and provides us the timely opportunity to reflect on the unique role this specialized court has played in the dispensation of justice over the past 11 years, and how this can be further improved and strengthened going forward. The ELRC has a unique place in the administration of justice with its specialized jurisdiction to deal with matters concerning employment and labor relations. Through your judgments and rulings, this court has gone a long way towards promoting a more equitable, fair, progressive workplace for employees and employers as well. Drafters of the Constitution of Kenya 2010 felt the need for there to be a specialized court on employment and labor relations. Harmonious industrial relations and a conducive work and business environment are central to our individual and national development. The symposium theme, to wit, the place of the Employment and Labor Relations Court in promoting social justice and economic prosperity, recognizes this very critical connection and thus the importance of the work of this court. The judiciary's strategic vision, the social transformation through access to justice, emphasizes a people-centered justice approach that places the justice needs and justice problems of our country and faced by our people at the center of the administration of justice. It recognizes the multiple avenues through which Kenyans access justice and the agency of the people, workers, employers, and their representative organizations and institutions. The next four days, as in relation to the stage developing realistic and be substantively improved. I further urge you to engage, to learn